Thank you everyone for joining us for our monthly webinar where we discuss a variety of financial topics from the perspective of an estate planning attorney, a CPA, and a financial advisor. We're in the middle of a series where we're spotlighting each of us. Today's webinar is Estate Planning Basics, presented by our estate planning attorney, Sophia Kim Sakamoto. Last month in our February webinar, I discussed some of the latest tax law changes and how they affect your 2020 and 2021 taxes. You can find a recording of it on YouTube, and you can find the link where you signed up for this event. And next month, we'll be spotlighting our financial advisor, Donna Lee. Donna couldn't make it for today's presentation because she's on maternity leave, but she will be back with us next month. So today's speaker, Sophia Kim Sakamoto, she's an estate planning, probate, and living trust attorney with offices in Buena Park and Mission Viejo, California. Yuri Yu, I'm a CPA located in Fullerton, California. And Donna Lee is a certified financial planner, and her office is located in the city of Orange. If you have any questions during the webinar, please type them in the chat box, and we will do our best to answer them at the end, time permitting. And please note that this webinar is being recorded. Please also be aware that this presentation contains general information, no legal or tax advice, and no attorney-client relationship or privilege is established by this presentation. And if you have a specific question, you can contact us after the webinar. So with that, let's get started. Sophia, we hear a lot about how estate plans are really important, but is it really something that everyone needs? More importantly, I guess, what is an estate plan?
Thanks, Yuri, and thanks everyone who's participating today. Really wanted to talk to you about estate plan basics. And for those of you who are asking, what is an estate plan? Do I even need one? Well, an estate plan is just writing down what's going to happen to my assets, who's going to be in charge, and doing that in advance so that the default laws of California won't take effect. And generally, an estate plan will consist of a living trust, a will, financial powers of attorney, advanced healthcare directive, also known as a healthcare power of attorney. And really, these documents are comprehensively going to cover all aspects of decision making. And we're just trying to, again, have a plan in place for someone to manage your assets for you when you're either alive but incapacitated or you're not here anymore. So proper planning now to avoid problems later. I tell my clients, like, if you're in that situation, you're either, incapacitated or you're not here, it's too late. You can't make those estate planning documents. So it's good to do it in advance. So the rule to know in California is that if the gross value, so I'm not talking a house minus the mortgage, it's the total value, the gross value of assets at the date of death that are in your name only. If it's over $166,250, then the assets have to go through probate court. Now, this calculation does not include joint accounts. It does not include assets with beneficiaries. So for example, husband and wife own a property, wife passes, if it's held in joint, then it goes to the other spouse, no probate court. But what if they both go at the same time? What if one person who is alive doesn't do anything and now they go? What happens to this asset? Well, if you're in California, most of the time that property will probably be over $166,000. And if you have nothing in place, it will have to go through court. If you're a single person, especially, then you just probably have a house only in your name. Maybe you have bank accounts only in your name. If they don't have beneficiaries, if something happens to you, where does it go? If it's all together over $166,250, it has to go through the court because only the court can decide what's going to happen, who it goes, who's in charge, who's gonna, get these assets. The bank will not release that money without a court order. The title company will say, I need a court order to tell me who can sign this deed. The person is not here. If it has a named beneficiary, like your retirement accounts, you probably put a beneficiary on there. If you have a life insurance, there's probably a beneficiary, even some checking accounts. Then whoever's on the beneficiary will go straight to that person. Even if you have a trust, it won't go to there. It'll go to the person that's named. So keep that in mind as we talk about what exactly is probate then. Well, probate is that court process to settle an estate when someone passes away. This is where the court figures out, okay, how much is in the estate? Who's the heirs? Who's going to be the administrator? Is there a will? Who's the executor? All of that. And then a conservatorship is when you are alive, but you cannot make your own financial decisions. You're incapacitated. Well, who's going to sign, who's going to access this bank? Who's going to write these checks? Who's paying the mortgage? If you don't have anything written down, the court will decide in a conservatorship and appoint someone to manage your finances and your health decisions for you. It went, of course, when you go through court, takes a long time. It's very expensive. Last year with the pandemic, all my probate clients, they had to just be on hold because the court shut down for a few months. So it just could be delayed because you're depending on the court to say, yes, do this, here's the hearing date. And usually in LA and OC right now, hearing dates are like 6 to 8 months out. Takes a long time.
That's really good to know. I know before I created an estate plan myself, I don't know why, I just kind of assumed that it was just for like really wealthy people. But, now I understand that it's kind of making some of these decisions beforehand so that your family doesn't have to worry about them, and definitely avoiding probate court seems like a big plus. I know that sometimes people think that a will and a trust are related or, kind of the same thing. Can you tell us what the difference is between a will and a trust?
Thanks, Yuri. And yeah, this is very important, the distinction. Now, a revocable living trust, revocable means that you can make changes at any time. And a trust is actually, I like to think of it as kind of like an entity, and you put assets in the name of the trust. So the difference is when you have an asset, like say you have a house, it's in Yuri's name, and Yuri's not here anymore, then the court has to, on Yuri's behalf, do all this research. Who's the heirs and where should Yuri's assets go to? But when Yuri puts her assets in Yuri's trust, so now the asset is titled Yuri as trustee of Yuri's trust, the trust owns this asset. Of course, Yuri owns the trust, but it's in the trust name. So the court doesn't need to worry about or, answer those questions about where does this go and what happens. We wrote it all down in the trust and it's held within the trust document. So you'll have assets that are in the name of the trust, which means it's inside the trust terms control that, the trustees managing whatever's in the trust. And then you'll have assets in your name only, things that you own. So obviously if it's in the trust terms control that. Anything that's not in the trust will be covered by the will. The trust is important because it's funded with assets that you put in there. Maybe you transfer your title of your house, maybe you put some bank accounts, maybe even a beneficiary of your life insurance or some other type of brokerage accounts. You can connect it to the trust in that way. Like I said, the trustee, kind of like employee, they're the manager of this trust. They're going to be paying the bills. Maybe they need to sell assets. They're going to be managing that trust and making decisions. And that's important because in your lifetime, you're the trustee, you're managing your assets, obviously. When you're not here, who's going to do that? We have a plan in place. Who's the next successor trustee to manage things? They step right into your shoes. They can start acting. It's just some paperwork. They don't need court authority, and they can go right into your shoes about, paying those bills. Maybe they have to sell property, do whatever they need to do. In incapacity and death. So that transition of power from Yuri to say I'm like the successor trustee, it's just paperwork, no court involvement, which makes it quicker, makes it faster, easier to manage without having to get the court involved. Now, there's a lot of different types of trust. The one that I was just kind of focusing on is the revocable living trust. And this is kind of the basic foundational trust. You could have more than one trust. You could have a revocable trust kind of for maybe you and your spouse or just for you. If you have it with a spouse, maybe it's your community property assets, things that you have together. But what if you have separate property? What if you're on your second, third, fourth marriage, you have assets from a prior relationship, or maybe when you were single, bringing it into a marriage, and you want to keep it separate. Well, I've had clients who have a community property trust with their spouse, and maybe each has their own separate property trusts. where they can hold things that are just for them. So I've had that also. You could also have an irrevocable trust. My client's telling me like, oh, it's very imminent that I'm going to be sued, and like I really want to protect my assets. This revocable type of trust, because you have the power to change it, you could take assets in and out, put new things in there, take things out. This one is not protected from creditors. If you set up an irrevocable trust, which means once you set it up and put assets in, you can't take it out, you can't really make changes. Those type of trusts are protected from creditors, and it's a tool to be used for asset protection. So you probably could have like a revocable trust for just kind of like foundational things, but maybe you have like a large asset that needs protecting. You can set up an irrevocable trust. Sometimes people do that for life insurance as well. I'm sure Donna will talk about that at her next presentation about using those. It's called an ILIT, an irrevocable life insurance trust. And also want to talk about, even within the revocable living trust, there's also something called an A trust and A B trust. Usually people don't use that right now because of the tax. They were using it in the past because of tax reasons. But an A-B trust basically says that when one spouse passes, then half of their assets go into a B trust, becomes irrevocable, and the other half goes to the one who's surviving. The one who's surviving, they can do whatever with their half, that's theirs, but at least for the deceased's, their half, it's saved for the beneficiaries that they had planned together. And then when the surviving spouse passes, then the distribution happens to the children. Usually this is used if you have children from a prior relationship, or you have beneficiaries that you don't want changed, because the alternative to that is the A trust, which is the most simplest type of trust. This is where one spouse passes, everything goes to the one who's surviving. And then the surviving spouse does have the power to make those changes. Some people, if you have children from like a prior relationship, you at least want to save half for your kids. Not that it's going to happen, but of course we have to say it out loud, is that the risk is that the surviving spouse makes the changes to the trust. Now there's nothing for your kids, right? So sometimes people use an A-B trust to at least save half. Of course, there's other techniques. Something I recommend is maybe like life insurance outside of the trust to provide for your children. Other different type of planning techniques, especially if there's blended families, or separate property assets that you want to protect. Okay, having said that, things that are in the trust protected from, avoiding probate, the trustee handles that. Anything else that's not in the trust is subject to probate. Remember that $166,000 rule. Anything in your name over that amount could go through probate. So if you do set up a trust, the goal is to put most things into the trust and other things not in the trust in just your name, low value. So then people ask me, then what's the difference, right? Obviously, trust handles trust assets, wills handles anything not in the trust. And the goal, like I said, to put most things in the trust. In this situation, the trust is the most important document. The will is just kind of like a backup plan. And in this type of special will that you do together with a trust, we say anything that's not in the trust, we put it in the trust. So the beneficiary of the will is the trust. Like in a regular will, you would say like, oh, to my kids or whoever. But here it's like anything not in the trust, I give it to the trust. And the reason why is because, of course, you've got your property and bank accounts in the trust, avoiding probate. And then if you forget about a bank account or property outside of the trust subject to probate, this pour over will catches everything else, puts it into the trust. It's literally called a pour over will. And our goal is to have nothing out here, but if we did, at least this will catches it. And if I did not have this will, then these assets just go by the default laws of California, which may or may not be what we want. And so that's why this will is just kind of backup plan, but very important to have. But remember, the will is not effective when we are alive. That's where a power of attorney comes in. I'm sure you've heard of this document. And this is used when you are alive, but you are incapacitated. What if you have a bank account that you forgot to put in the trust, or you got an inheritance, it was just in your name, but now you can't manage it? If you have a financial power of attorney in place, then you're naming an agent to manage those non-trust assets for you when you're alive but incapacitated. Very important to have, and it expires at death. So some people, I get on the phone a lot, my parents passed away, but I have power of attorney. So now what do I do? Well, the power of attorney expires at death. Anything that is in their name is going to now be handled by the will and executor, or if it was in the trust, then the trustee. Now it could all be the same person, the trustee who's over here handling trust assets, the executor of the will who is handling non-trust assets. If I hear attorney in fact, oh, then this person must be alive and they have assets not in the trust. If I hear executor, oh, okay, they're probably not here, but maybe they had a will and they have some assets that are not in a trust. It could all be the same person, they're just managing different categories of assets. Some issues if you don't plan, because maybe you're like, well, I don't know if I need to do one. Well, if you don't plan, I mean, that's still a plan. It's not a good one, but the default laws of California will apply. But something to note is, do you want your spouse or your children to manage your estate? Some people say like, oh, like I want my children to manage it. Or maybe they'll say like, oh no, this one child, but maybe not this child. Well, you have to write that down. If you have 3 kids, like who's going to be the one to take care? And there could be some issues. If you have joint accounts, and let me tell you, like I've had so many issues with this, where it's like, they've got 3 kids, but mom only had a joint account with 1 child. Well, when mom passes, it goes to that 1 child, they're the joint account holder. And the other 2 kids are like, what happened? Where's our inheritance? No, mom had a joint account with me. That's technically, that 1 child's money. In mom's mind, because she always tells, the clients tell me, oh no, they'll know what to do. But what if the child's like, okay, well, you brother, I like you, here's like $5,000, but you sister, I didn't like you, here's $100, So there's no obligation to split that. So for those type of accounts, if you put it in a trust, now the trustee, you get to decide who it's going to be, but at the same time, they have an obligation to divide that equally, use those funds for your trust and your estate. If you have it in joint accounts, again, it just becomes the assets of the account holder. They don't have to use anything for mom and dad's estate. And then who can access the bank accounts, right? So it's like you have an issue about who's going to be the one in charge and then who's accountable, right? So you don't have anything written in place. What's going to happen? If it does go through court, it takes a long time. For example, it takes about 4 or 5 months for the court to even appoint who's going to be in charge. So meanwhile, mortgage, bills, who's going to pay that? Like if there's a rental, where do the rental proceeds go? Like there's all these questions. So lots of issues.
Yeah, that's really interesting. I know I do hear a lot of like, oh, my kids will know what to do when I pass away or whatever. But you're really putting the burden on the kids to figure out what you wanted. It's a lot better to just have it in place so that they don't have to worry about it and they know exactly what you wanted to happen to everything.
Yeah, so, I had a client come. The realtor was like, "Oh, mom and dad died. Now the kids want to sell the property. Who's the one that's on? The one to take charge and sell it." Come to find out, way back when, mom and dad gave everything to uncle. Uncle was the 3rd joint account holder because kids were little and they couldn't put it in kids' names. So they're like, "Uncle will know what to do." No, he kept that property. So.
Yeah.
Definitely want to review your deeds, want to review your beneficiaries. If you have a trust, then definitely need to update that too.
And definitely avoiding court is sounding more and more appealing, especially these days with everything backed up so much. So moving on, we've been living in a world with coronavirus for over a year now, and it's caused a lot of people to think about what would happen if they were to get sick or have to be hospitalized, especially given these times. There's limited access, for family members. What types of health documents should we have in place?
That's a very good question. And, especially right now, so important to have an advanced healthcare directive. I'm sure if you go to the hospitals, the doctors, they ask you, oh, do you have an advanced healthcare directive? If you do prepare this, you can say, yes, I do. And then you can give them a copy. What this document is, it's naming an agent who can make health decisions for you when you're not able to tell the doctor or make decisions for yourself. It's appointing an agent. Now, this form, it's not like the doctor sees this form and then it's like an order to them. It's really to help the agent know your wishes and your preferences so they can communicate with the hospitals and make a decision for you. Not only about, like pulling the plug, right? That's very common, but elderly, like nursing facilities, maybe even like mental health institutions, maybe home health care, regular doctor's visits, maybe getting medicine and things like that. Anything that has to do with healthcare, it appoints an agent for you. And another important thing is that it has decision-making priorities. So I usually put like number 1 agent and then alternate number 2 and then 3. What it does is it sets a priority, because what if your whole family is arguing about what to do? Well, the person in the number 1 spot will have the final say and make that decision. Along with the Advanced Healthcare Directive, one more thing is that also this will be important for after death too, like funeral arrangements and so forth. This agent does have that authority to, talk with the mortuary and get things done and make those decisions. The HIPAA authorization, the hospitals are so strict about releasing those private protected medical records. So this authorization in advance to let them know that it's okay to talk with my agents. The living will is also a very important document. If you are very have strong feelings that if you are in a permanent vegetative state and there's no hope for recovery, you want to be comfortable, but your wish is to go naturally and you don't want all those machines to keep you alive, this living will is going to be important. If you have an advanced healthcare directive in place, your agent does make that decision, but sometimes they're left with a lot of burden or guilt. Did I make the right decision? All of this. If you have a living will, it's basically letting them know, like, it's okay, this is my wish. Sometimes eases some of that pressure in a very crisis situation.
Yeah, I think that's another area where you're not just planning for yourself, but you're really planning for your loved ones, taking that burden off of them so that, they don't have to be making those decisions on their own, just kind of trying to guess or assume what you may have wanted.
That's a good point, Yuri, because I tell my clients, like, this is really not for you because you're not going to be here. This is for like your family and the people who are going to have to use these documents to talk with the doctors, go to the bank, sell your You're just trying to make it easy for them. If you don't have this in place, they have to go to court. They have to they have to be stressed out to get a court order and try to, settle the estate.
So we've talked about protecting our assets and planning for healthcare. What about kids? I have minor children. How do I name a guardian for them in my documents?
This is a good question, and one that I get quite frequently because I also deal with families and those kind of starting out. Maybe they have young children. And, the question comes up, well, what happens if mom and dad are not here? And obviously, if they're under 18, they cannot manage money. They cannot enter into contracts. They are minors, and a guardian will need to be in place for them. There is 2 types of guardians. One is the guardian of the person, like the day-to-day, going to school, custody. And then there's the guardian of the estate, which is the money, the inheritance. If the parents are not here, obviously their parents' money will go to the kids as an inheritance. If they're under 18, how can they manage that? They cannot accept that. And if you don't have any, documents in place, those assets might have to go through a guardianship court process to hold and manage through the courts for that minor until they turn 18. And then at 18, they get all of it all at once. So usually if you have a trust, and this is an important reason to have a trust when you have minor children, so that the trust and the trustee can manage those monies for your children, not just until age 18, because 18 I feel like is a little bit still too young to kind of handle things. Maybe you want to spread it out until like maybe 20, 25, 30, so forth. You figure like, okay, maybe they're in college around 18 to 20. Maybe they're, starting to enter into the workforce. Maybe they need a down payment for that. They're getting married, like these life stages. And instead of giving everything at 18, of course, the goal is to provide for the long term. Not that they're irresponsible, but maybe they just don't have that financial maturity yet at 18. So sometimes it's good that the trustee manages it for them. Of course, the trustee can use it for health, education, maintenance, or support, but just they can kind of spread it out so that the child will have enough if they need it. Now, that's the guardian of the estate, which is usually the same as the trustees if you have a trust. And I want to say this though, just because the parents name a guardian at this time, like you don't know what's going to happen 5 years later, right? What if the people that I name now, they are like, very sick. Maybe they're not here anymore. Maybe they're in jail. Maybe they've got like some issues where they're not qualified to be the guardian. So this part, you can't avoid the guardianship court process because the court will decide who's in the best interest of the child. Of course, they'll say, okay, well, did parents leave a will? Did they name a guardian? And that guardian does have priority or a lot of weight on who will be the guardian. But, the court has to do its own due diligence, own investigation to see if those named guardians are truly in the best interest of the child. If it's not, okay, go on to number two. Are they good? Are they qualified? There's also something called a temporary or permanent guardian. So, mom and dad, something happens to them. It's not like the next day there's this like court hearing. Usually it's not for like 4 months to a year out. So sometimes people name a temporary guardian, someone local, keep them in school, like just kind of manage what's happening. And then a permanent guardian until the court hearing, because maybe the real guardian or the permanent one, maybe they live out of state or something, like it's hard for them to get to immediately. So you could also name a temporary or permanent guardian. But again, very important to have guardians named in the will.
Yeah, this sounds like something that's really important to do to make sure that you are the one that's choosing the guardian for your children and not trusting the court to make that decision for you.
It's true because, families, dad's family says, no, we want to be the guardian. No, mom's family wants to be the guardian. There's like this big fight. Well, if mom and dad had a priority list, then, that will be respected.
Yeah. So speaking of children, a really common question I get is, should I add my child to the deed of my property? And if so, how? How can I do it?
That's a good question. You don't understand. I get that so many times. I'm sure you do, Yuri, as well, about adding your child to the deed. And I think it's because most people think, oh, this is like a way to avoid probate without having to do like a trust or will. I'll just add my child to the deed. Before you do that, have a consultation with either an attorney or a CPA, because there are some consequences to that people may not understand. Some ways to transfer your ownership to your child. And by child, I mean like someone over 18, right? You can have them as joint tenants, which means it's like, mom, dad, and child all together as joint tenants. You could just gift it to the child outright. And then, of course, after death, maybe you do a will or a trust, say after we're here, not here, then it goes to the child. Just want to talk about those. There could be some other ways. I'm just going to focus on 3 right now for this presentation. When you have joint tenants, it means that there's what's called a right of survivorship. So say you have 3 people as joint tenants. Well, one's not here, it'll go to the remaining 2. If one's not here, it goes to the other. So the hypothetical is, mom is the original owner, and then now they've added 1 child. In that time, there won't be a property tax reassessment because mom's still the owner, right? Even though child is on. When mom passes away and now it goes to the other person on the title, child, there will be a change of ownership at that time. And so there could be some property tax reassessments. Prop 19 you may have heard about. Prop 19 was or is a law that just enacted, passed in November of last year and effective in February. What it does is that it limits the property tax exclusion. So before, parents to child usually excluded from reassessment for property taxes. In other words, child could still maintain parents' old property tax values, keep their old property tax values the same. Now there's some qualifications. The main one being that parents have to live at the property, child also has to be living in the property for that qualification. Otherwise, if it's an investment property or if child doesn't live there or if there's other type of value restrictions, then the property is reassessed for today's market value. So, keeping that in mind about property taxes, you may have to think about that even though it's joint tenancy. Yes, it avoids probate because it's whoever's on the joint tenant title, but there could be some capital gains issues, which Yuri's going to talk about in a moment. You could also gift the property outright. So here, as I was mentioning, there could be a Prop 19 issue. What if the child doesn't live there? Then there probably will be a reassessment for property taxes. This is the taxes that you pay to the county every year. And if you give the child that property, well, child is the owner. Is parent still going to live there? Does parent have to pay rent? What if the child kicks you out? I mean, I don't think they're gonna, but I mean, who knows? What if child is like, I really need to sell this house. Like, I'm in dire straits. Like, or I really need to put like a reverse on this, or I need to pull the equity from this house, or whatever it is. Child is the owner. Also, because it's the child is the owner, now child gets in a car accident or they get sued, this house is part of their estate, subject to any like liability. Also capital gains issues and tax issues, which Yuri will discuss in the next slide. After death, there still could be some property tax reassessment. It really depends. Again, same issues. Does the child live there? When did the parents pass away? And some other types of issues with that. But the good thing is that parents are still the owners until they pass. So they're still able to maintain that level of control. There is a tax benefit, a capital gain step up. And the way that you can transfer that is through a trust or will or probate. There's also something called a transfer on death deed. Be careful of that because that provision does expire. It's set to expire. If you're thinking about that, you should consult an attorney. That type of deed is just saying that, a very simple one, if I'm not here, then it goes to X, whoever it is. That is also a way to do that. Yuri, as I was mentioning before, there are some critical tax consequences to know about each three. Do you want to kind of explain using this hypothetical about some of this tax issues that could arise?
Yeah, when it comes to transferring ownership of a home, a lot of times people think that since no money changed hands or whatever, it's not a big deal. It doesn't need to be recorded or anything. Or they think, my kid is going to get everything anyway. They're going to get my house, so I might as well give it to them now while I'm still alive to avoid probate or whatever. But there are tax consequences of transferring ownership that everyone should be aware of. So I just made up a simple example here, and these are all scenarios that I have seen in my career. So here's an illustration, the three options: joint tenancy, gift, an outright gift, and inheriting after death. Mom purchased a home in 2001 for $250,000. She's lived in it as her primary residence since then. Daughter is her only beneficiary, never lived in the house. Mom passes away in 2020 when the home is valued at $450,000. If mom transferred the property to her daughter as a gift while she was alive, mom is supposed to file a gift tax return reporting that gift, whether it was 50% joint tenancy or 100% of the property. And when you do that kind of gift, you should get an appraisal done on the value of the home at the time of the gift. And just adding someone's name onto title or deed is effectively, you are transferring ownership and gifting the property to them. But the real tax consequences kick in when the property is sold. If they're joint tenants and they sell the house, mom might not have to pay any capital gains tax on the sale, assuming that her portion of the gain is under $250,000, which is the primary residence gain exclusion. But daughter is going to have to pay capital gains tax on her portion of the gain because she never lived in the house. She can't use that primary residence gain exclusion. If daughter owns 100% of the property, then she's going to have to pay capital gains tax on all of the gain. So in this example, mom passes away. 2020, home is valued at 450. What is the taxable gain if the house sells for 450? Taxable gain is the difference between the sales price and the cost or basis in the property. If daughter owned the property in joint tenancy, the gain is $100,000, the taxable gain. That's because half of the property that mom owned gets a step up in basis. So step up in basis to value as of the date of her passing. So half of 450 is 225. And then the half that daughter owned doesn't get a step up. So her basis is half of the purchase price of 250, which is 125. So her total basis in the property is 350, which gets us to the $100,000 of taxable gain that daughter is going to have to pay when she sells the property. If daughter was gifted 100% of the property while mom was alive, then her taxable gain is the difference between mom's purchase price of $250 and the sales price of $450 for a taxable gain of $200,000. Definitely out of the three, this one is the one with the highest amount of taxable gain. And if mom never gifted the property and daughter just inherited it upon mom's death and then just turned around and sold it for $450,000, there is no taxable gain because of that step up in basis, which is, the value of the home when she inherited it. So this is just like a simple example just to illustrate the tax consequences of transferring ownership. This happens all the time and people don't know until it's too late, until the property is sold and then daughter gets a 1099 and she's like, oh, I didn't even know I was on title. And now I have to pay tax on this house that I didn't even know was part mine. And do know that when it comes to like investment or rental properties or any time when there's like depreciation or a 1031 exchange involved, the differences between these three scenarios can be quite large and significant. So definitely, if this is something you're thinking about doing, transferring ownership of a property, consult with your attorney, make sure that it's done correctly, and then also consult with your CPA just to make sure that there's not any like unforeseen tax consequences that you're not aware of. In these three scenarios, Sophia, how are property taxes affected?
That is a good question. And, when you add someone as a joint tenant, I guess for tax purposes, they're considered an owner. For property tax reassessment, it's not considered a change in ownership because, mom, if she was the original owner, then she's still on title. So technically no change of ownership occurred. She still owns it. Only when mom passes will there be considered a change of ownership because now it went completely to daughter. And at that time, there could be a property tax reassessment. This is what the county charges every year. And it'll probably jump up to the date of death values. Now, if you do a gift outright, then of course, the ownership changed from mom to child. There will be a reassessment for property taxes. So on the one hand, you're like, oh, I'm going to avoid probate by giving this property to my child. But at the same time, there could be some property tax increases that you may not have considered. And then after death too, especially with that Prop 19 in effect now, if child, in this hypothetical, she never lived there, she's not going to live there, then there could be some property tax reassessment as well. At that time, daughter could decide to move in, then that maybe could change things in terms of property taxes. But for the most part, maybe she'll say, oh, it's not worth it for me because property taxes are so high now. And then, maybe she sells it. So that's also something to consider as well. Okay, the time flew by, but we're at the end of our presentation. Yuri, did we have any questions? I think we have like maybe 3 minutes for some questions.
Yeah, we have a couple questions. One is, when should a trust be a beneficiary?
That's a good question. And this could be used, I usually say when you have life insurance, I think that's kind of a good way to make the trust a beneficiary. So remember, most people just put like a house in the trust. If you do that, then it's a non-liquid assets. It's just like a piece of real property. But the trust does need some cash. It does need some cash to manage things, pay last minute expenses. Also, if you have a lot of benefit, maybe you have 2, 3, 4 kids, and you only have one piece of property in this trust, are you going to sell it and divide it 4 ways? What if one person lives there? Are they going to buy them out? Even in that situation, you have to think about property tax reassessment as well. If you have the life insurance and the trust as the beneficiary, then something happens to you, the money goes straight into the trust. For example, you say to my 3 kids equally, maybe one kid wants the property, the other 2 wants it in cash. If you have enough cash in there, maybe through life insurance proceeds, the other 2 can get the cash, one could have the property, assuming they're equal value. Even in a married couple, they want to say, oh, spouse number 1, and then, kids number 2. Be careful of that, because again, if kids are minors, how can they accept money if something's happening to mom and dad? And even in that situation, I would recommend a trust as the beneficiary. Something happens to husband, it goes to the spouse, but at the same time, the trust holds the money for them, even for the benefit of the spouse. If something's happening with the spouse, then at least the trust has a plan in place for the spouse, kids, and so forth. Retirement accounts, I don't usually recommend the trust as the beneficiary. Retirement accounts have special tax consequences, so you may not want a trust to be the beneficiary. They're going to be taxed at the highest amount. Donna will probably talk about that at the next seminar, so you can be sure to tune in for that one. Anything that's cash, checking, savings accounts, brokerage, investment, stocks, you can put the trust as a beneficiary for those type of accounts.
And then I think we just have time for one more. What is the difference between joint tenants and tenants in common?
That's a good question, and I just had a seminar on that yesterday. But tenants, joint tenants, if one person is not there, whoever's the next person on the title, it goes to them automatically. Tenants in common, even if there's like 2, 3, 4 people, if one person is not there, does not go to the others automatically. It'll go to your estate, your heirs, your family, your estate plan. Now, when you have joint tenants, you have to have equal ownership. If you have tenants in common, you could have different percentages. A really common thing is like, brother and sister buy a house together, boyfriend and girlfriend, that happens a lot. Maybe somebody pays 30% of the down payment, somebody pays like 70%. Maybe you split the ownership like 30%, 70%. You could do that with tenants in common. Giving the boyfriend and girlfriend scenario, if you have joint tenants, if something happens to you, it goes to the other person. Maybe you don't want that. Hey, I put in a deposit. I want it to go to my family. Maybe you want to make that tenants in common and set up an estate plan. However, because it goes to your estate, and probably your portion could be over $166,000, you may want to make that portion part of your trust. Also, if you don't have any vesting language in your deed, so this happens very typically, to Sophia and Yuri, period. If there's no vesting language, joint tenants, tenants in common, the default is tenants in common. And if that's the case, something happens, it might have to go through probate.
Very, very interesting. I know I get a lot of questions when people are buying a home and they're like, which box do I check? And I'm like, ask your lawyer, I don't know.
Oh, if that's the case, then if you're a married couple, community property with right of survivorship. If you have any questions about that, talk to me afterwards.
Okay, well, that's it for today. We did have a few more questions. I'm sorry we couldn't get to them all. Please feel free to contact us directly if there's anything you need assistance with. Thank you for attending our webinar. We know your time is valuable and we strive to provide content that is interesting and informative. Please join us for our next webinar. It's on April 16th at 12 p.m. Donna Lee will be discussing financial planning mistakes and how to avoid them. We'll be sending out a short survey in just a few minutes. We appreciate your feedback and do let us know if there are any topics you'd like us to speak on. Thank you again and have a great weekend.